Good afternoon and welcome to another session of Lunch and Learn. And today we'll be discussing something that happens quite often in maintenance matters, and that is if you have a maintenance order that during a stage or some stage during this whole process that you need to apply for an increase or even for a decrease of the maintenance order. So what we'll be discussing today is how to apply for the variation of a maintenance order. And the brief overview of what we will be discussing today would be what is the process that needs to be followed that you could actually request for an increase at the maintenance court. We'll explain to you what is meant by the term good cause as a requirement for a variation of a maintenance order, as well as the documentation that is needed for a variation. We'll also be addressing how to complete the J107 form, that is the form that's needed to apply for maintenance or the increase or the decrease thereof, as well as the factors that the court would consider in such an application for a decrease or for an increase of maintenance. We'll also be discussing the deterioration in the maintenance debtor's financial position and subsequent marriages, as well as the cost of living and how does that affect the variation of the orders, if orders could be made retrospectively and so forth. So this is all that we will be dealing with today. Some logistics. Yes, if you have registered, and welcome to all our online registrations or registrants. I see that we have quite a number. We actually have a record number of people watching online. Welcome to all of you. If you have registered on the Lunch and Learn website, then you would have received a link that would allow you to download some of the documentation. And I can just bring up the screen to show you exactly what is meant by that. If you receive the link by registering on www.lunchandlearn.org.za, you would receive a link with that is basically the link at the top that will give you access to the live webinar where you will be seeing the presenters. There's also some pre-reading material. In this instance, there is actually some pre-reading material that you can browse through. But most importantly is the handout and resource section, where you would have all the documents that we are referring to. The J107 form, for example, the handout, the slides, the bundle of case law on good cause, extract from the LexisNexis dealing with the rescissions and variations and suspensions of orders, as well as examples of founding affidavits that could be used in maintenance matters. So this is for all the registrants that have registered. But without further ado, I'm going to hand over to Erin O'Neill, one of our candidate attorneys that will be leading this presentation. And I'll be joining you guys again with a discussion portion right at the end. And over to Erin.
Let's get right into it. So, firstly, is a discussion with reference to case law on when you may request the court for an increase. So there are a few requirements which have to be met before the court will allow you a variation of your original maintenance order. So this is the sufficient reason or adequate cause requirements. This is set out in legislation. So section 16(1)(b) of the Maintenance Act reads that after consideration of the evidence adduced at the inquiry, the maintenance court may, in the case where a maintenance order is in force, this is your original maintenance order, that court may make a maintenance order contemplated in paragraph AI in substitution of such a maintenance order or discharge that maintenance order. Section 8(1) of the Divorce Act states that a maintenance order or an order in regard to the custody or guardianship of or access to a child made in terms of this act may at any time be rescinded or varied, or in the case of a maintenance order or the order with regard to access to a child may be suspended by a court if the court finds that there is sufficient reason therefore. So we see now that both the Maintenance Act as well as the Divorce Act states that there has to be a sufficient reason why you are applying to vary your original maintenance order, as well as adequate cause, but we will get to that. So for now, always remember that there has to be a sufficient reason why you are applying for a variation. So you can't just apply for variation if there is no reason why you're doing that. So basically it states that a maintenance order may be varied if the court finds that there's sufficient reason therefore. And then section 10.2 of the now repealed Matrimonial Affairs Act requires good cause for the variation. And this was also confirmed in the case of M versus M. So now your first questions will be, what would be a sufficient reason or an adequate cause to apply for a variation of a maintenance order? Well, the variation order may be an order where the good cause exists. So, for example, it can be varied either because the amount has become insufficient for your needs, or if you can no longer afford to pay the amount of maintenance. So, for example, the increase because the child's needs has increased, because as we all know, things change, your circumstances change, and you might need a little bit more money. So then you can apply for an increase because your circumstances have changed. Or for example, if you are the person paying the maintenance amount, your circumstances might have changed. You might have lost your job, or you might have gotten a new job which pays less, and now your expenses have become more than your income, and therefore now you want to have a decrease in the maintenance amount because you can no longer afford to pay that original amount in the original maintenance order. So once such good cause is alleged and lodged, the maintenance officer may investigate and instate an inquiry in the maintenance court. So you go and lodge your application, you fill in your J107, we will get to that and how to complete that form. But once you've done that, you have to indicate your good cause and your reason for applying for the variation, for the increase or the decrease. That maintenance officer will then investigate it and launch an inquiry in the maintenance court. So this has been confirmed in M versus M, where the court stated that the Maintenance Act in itself does not provide a test to be applied when an application is made for the variation or discharge of a maintenance order. So what does this mean? So the variation, as we've said, this is where you apply either for an increase or decrease in the original maintenance amount that's payable. Or the court can also discharge. So you now want to discharge the application in its entirety. So you feel like you don't need to pay maintenance anymore, or you don't need the maintenance amount anymore, that order can be discharged. So the court in the Roos versus Roos stated that variation will be ordered not only in cases of breach by either party, but because there has been such a change in the conditions that existed when the order was made, that it would now be unfair that the order should stand in its original form. So the court just basically reiterates what I've said, that if there's been a change in your circumstances, your conditions of living, for example, you lost your job, so now you have less money, you wish to decrease the maintenance amount to meet your needs as well, because your expenses have now become more than your income. Or for example, your conditions have changed and the child's needs have changed, so you require an increase to keep up with the needs of your child. So there's sufficient reason that you are applying for the variation, as well as a good cause, because your conditions have changed. And so the original maintenance order is not meeting your needs as of now, and therefore you're applying for the variation. The court in Havenga versus Havenga stated that courts will generally only vary an existing maintenance order where there has been a change in conditions. Otherwise, there would not be a sufficient reason for a change. So this just brings us back to what I've said, that there has to be a sufficient reason why you are applying for the variation. There's been a change in the conditions of living, change in your circumstances, change in employment, for example. All of these things play a role in why you might apply for a variation. But if you're applying for a variation just because you want to, but there's no sufficient reason, the court might not grant that variation because you didn't show that there was sufficient reason for it. An example of this would be if the original maintenance order was obtained 1 month ago, and now a month later you are applying for variation. Your conditions have not changed, your needs have not changed, everything remains the same as it was a month ago. Then the court will not grant that variation order because you have not shown the court that there is sufficient reason and adequate cause why you are applying for this variation. That's just an example of a situation where the court might not grant the variation. So another thing that will play a role in your application for a variation is how frequently you apply for the variation order. So do you go to court every month and apply for an increase? That will play a role in whether the court will grant you that increase. So the frequency of applying for a variation of a maintenance order may also have an effect on the successfulness of your application, especially where an applicant constantly applies to have their maintenance order increased or decreased without a valid or true reason for it. So as I've said, if you go to court every month and you apply for an increase, or every month you go and apply for a decrease, that constant application will have an effect on whether you will be successful in being granted that increase or decrease in your maintenance amount. Because if you go every month, you're not being true and valid, because there's no sufficient reason why you need to apply every month for an increase. But as I've said, if you applied within 6 months, because now you had a change in employment and you can now pay more maintenance, that is a sufficient reason for applying for an increase. But applying every month without having any change in your circumstances, that is just being constantly applying, and then you won't be successful in that application. So these types of applications may amount to vexatious proceedings. So what does that mean? Well, it just means that you are constantly applying, you are going to court, you want to just get more money every single month, and you don't have sufficient reason for it, so it amounts to vexatious proceedings. So the applicants must only apply for a variation if they really need it and have an adequate cause to apply as such. The court in Cohen versus Cohen and Gravenstein versus Clayton stated that repeated variation applications amount to vexatious steps. So your reason is not true and valid. You are just doing this to go to court, and you're not doing it because you really need that variation. And so don't do that. Just rather only when you have a sufficient reason to apply for the variation. Don't go every month or every other month and apply for a variation if you do not have sufficient reason or adequate cause to apply for such. So the court in Watson versus Watson held that the time between the initial maintenance order and application for variation may still warrant a variation if it is within the children's true interest. What does this mean? Well, as I've said, if you go apply every month, is that really within your child's needs and interests? Or do you just want more money every month? But, for example, if you have applied for the original maintenance order in January, it's been granted. Now, a few months later in June, you now see that the amount given is not sufficient to meet the needs of your child. That may warrant a variation, provided it is in your child's interest. I'm not saying that if you go and apply after a month that it won't be granted, because there is still the possibility that after the initial order was granted a month later, you might have lost your employment. And so you do need a bit more money now. Or, for example, the child had to move from one school to another school, and now those costs are more than the initial cost, which you completed when you did the J101. So then you can apply for a variation because you have reason to do so. Your conditions have changed. All I'm saying is that if you go apply every month without sufficient reason, that will amount to vexatious proceedings. So the court in Darway versus Darway held that frequent variation applications are undesirable and they are unpractical. We've discussed this. The reason why it's unpractical is because you don't really need a variation. So you're just going to court and hoping you will get an increase, but you don't really need that increase right now or the decrease right now. So it's just undesirable, it's unpractical, and it should be avoided. You should rather just go and apply for a variation when you have sufficient reason for such variation. So what does the term good cause as a requirement for a variation of a maintenance order actually mean? So maintenance courts may vary existing maintenance orders if good cause exists. Whether or not a good cause exists has to be assessed on the particular facts of each case. Something that you should always note is that each case is different. No one person will have the same facts, and therefore whether a good cause exists in your circumstances might be different than someone else's circumstances. So don't compare your maintenance application with someone else's, because the facts are not always the same, and therefore whether good cause exists will be assessed based on your facts and your facts only. So sufficient reason and good cause is a prerequisite to applying for a variation of a maintenance order. So what do we mean when we say you need good cause? Well, change in financial position is not necessarily required, but change in financial position can establish a good cause. So as I've said, you've lost your job, and so now you cannot afford to pay the amount of maintenance in terms of the original maintenance order. This can be a good cause as to why you are applying for a decrease. And the burden of proving whether there is good cause to apply for this variation, either the decrease or the increase in the maintenance amount, will lie with the party seeking variation. That person who is now applying in terms of the J107, the person going to court applying for the variation order, that person has the responsibility now to show sufficient reason why they're applying for variation either in the High Court or the Magistrates Court. So the obligation to prove the good reason, the sufficient reason and good cause why you are applying for maintenance order, that lies with the person who is approaching the court that day. So if you, as the mom, for example, you now want a variation, you want an increase because the child's needs have changed, you now have to show that there is sufficient reason why you are applying for this variation. Or for example, dad has lost his job. Now he wants to apply for a decrease in the maintenance amount. Dad now has the responsibility to show that reason, so that he lost his employment. The obligation lies with him to prove to the court that there's been a change in his circumstances which now warrant a variation of the original maintenance order. Okay, so there are various factors which can play a role in establishing whether good cause exists. I will quickly read over all of the factors that the court will consider, and then I will go into detail on each one of these factors. So the court will consider these factors not exclusively, but these are the factors that can be considered together, and which might play a role in the successfulness of your variation application. So the first one is failure to establish material circumstances of financial position on or any attempt to mislead the court. Okay, alteration in financial circumstances, spousal maintenance with regard to factors in Section 8 of the Divorce Act, moral considerations, deterioration of maintenance debtors' financial position and the cost of living, So those are the factors that the court will consider, as well as cohabitation is also a factor that the court will consider. So, failure to establish material circumstances of financial position and or any attempt to mislead the court. So, misleading the court in terms of what your financial position actually is. So, if a party fails to establish the material circumstances of their financial position, it will be detrimental to their case. So, if you fail to show the court your true financial positions, it might be detrimental to your case. So the court will not likely grant an increase or decrease if the party's financial position does not allow for it as such. So what does this mean? What does it mean when we say that your financial position does not allow for it? So you cannot mislead the court and say that you have lost your job if this is not true, because the court will not likely grant an increase if your position does not allow for it. So a party wishing to apply for an increase must show that their financial position has diminished and that they need more maintenance as a result thereof. So what this means is, how can your financial position be diminished? You have lost your job, or you've applied for a new job, but your pay is now less. This means that your financial position has diminished, or your expenses become more than what you earn. So you now have more expenses to pay because you are paying the maintenance amount, you are paying for schooling fees, or you just have more expenses. Your groceries have gone up. For example, all those things can play a role. So now your financial position is less than it was at the time the original maintenance order was made. This means that now you'd require a decrease, but you have to show this to the court. And you cannot lie to the court. So you cannot mislead the court into believing that your expenses are now more than your earning capacities when this is not the case. So a party seeking a decrease has to show that they have a diminished financial position and as such need a decrease in the maintenance amount payable by them. This we have discussed. Any attempt to mislead the court will be detrimental to your case. As I've said, misleading the court includes lying about your financial position or lying about the expenses, lying about your income, because dishonest misconduct will amount to an abuse of court processes and may be fatal to a party's case for variation. Thus, the parties must never lie about their financial position when asking for a variation of a maintenance order. This is very important. You must not mislead the court or be dishonest when you are in court. Always tell the truth, because if you are not telling the truth, it will be detrimental to your case. It will affect the successfulness of your application. Always be honest when talking about your financial position. Always be honest when talking about your expenses and your child's expenses. Do not make up facts because you think it might be to the benefit of your case. It will not, because misleading the court is an abuse of the court process. Just be honest, and then this will determine the successfulness of your application. Alteration in financial circumstances. What does this mean? Well, a change in the party's financial circumstances may warrant their application for a variation of payable maintenance. So, for example, if a custodian parent's expenses, the custodian parent is the primary parent, so the child lives primarily with this parent. If their expenses have increased to such an extent that they now require more maintenance for their child's reasonable needs, then they may ask for an increase in the maintenance amount. So what does this mean? So the custodian parent, the primary parent who takes care of the child on a day-to-day basis, their expenses have now increased. So their expenses have become more than their income, and therefore they now require more maintenance. So they may apply for a variation to have the maintenance amount increase because they can now show that there's been a change in their financial circumstances. The child's reasonable needs have increased, or the primary parent has lost their job, and so now they require more maintenance to care for the child, for example. These are all examples of how there can be a change in your financial position. Another example, if a non-custodian parent, so the non-primary parent, the child does not live with this parent on a permanent basis, but rather visits this parent, their expenses may also have increased to the extent that they are no longer able to afford the amount due. They may ask for a decrease in the maintenance amount. So this makes sense. If their expenses have increased to such an extent that they cannot afford the original maintenance amount, they can apply for a decrease. Another change in the non-custodian parent's financial position is, as I've said, is where they lose their job. They cannot now pay the original maintenance amount and still make ends meet. So this is a change in the financial position which warrants variation because there's sufficient reason and good cause for it. However, there are circumstances where a mere change in financial circumstances did not warrant the granting of a variation of a maintenance order. So let's look at an example. The court in Davis versus Davis held that an upward variation of maintenance was not justified due to increased expenditure due to immigration. So this case serves as an example that mere immigration and increased costs will not automatically justify variation in the maintenance amount, but it may give context why the variation is being sought. So basically, this case is saying that the mere fact that you have decided to immigrate and there has been now increased cost due to this immigration, this is due to your own choice. And so this may not warrant a variation, because as you will see from there's a slide to follow, that if you apply for an increase or decrease, the change in your financial position must be out of your control. So you can't apply for a variation because you are now deciding to immigrate to Australia, for example, and now you have increased expenditure, because that was not out of your control. You made that decision to do that. And so this is just basically what this case is saying, is that it's not justified because it's not automatically justified just because you have now decided to go and move to somewhere where your expenditure is increased. But it does give context why you are applying for variation. Then we have spousal maintenance with regard to factors listed in Section 8 of the Divorce Act. So, in an application for the variation of a child maintenance order, the granting of spousal maintenance may also be relevant. So you will consider the factors that are considered by the court in awarding spousal maintenance when you also consider for the variation of child maintenance. What are these factors? The parties' conduct, the age of the parties, their health, and their ability to support themselves. So the court will also consider these factors that it considers in awarding spousal maintenance when it considers whether to grant a variation of a maintenance order. So basically, this is a lot to digest right now, but it just comes down to the same point, is that you need to show the court that there's been a change in your circumstances. You know, your expenses, your employment, or the fact that your child's needs have increased or even decreased. So your financial position is your point of departure and how your living conditions have changed. So the next factor is moral consideration. So it's important to understand that in South Africa, we have moved away from the fault-based divorce approach. So that is no longer relevant. So it does become questionable whether moral considerations or conduct of a party will actually have an effect in whether a court will grant a variation order. So a party's dishonesty, however, will amount to vexatious proceedings. We have discussed this right at the beginning of the webinar, where I said that when you are in court or you are applying for a variation order, you have to be honest about your true financial circumstances and be honest about your children's needs. Do not make up facts because you think it will have an effect on the successfulness of your application. This will only be detrimental to your case because you are being dishonest, and it will amount to vexatious proceedings, which is not good. So rather just be honest, because the court will take all these factors in consideration when deciding whether to grant your variation. So be honest. Dishonesty does happen, and it will be detrimental to your case. So, deterioration of maintenance debtor's financial position. So what does this mean? We've discussed this actually already. It is the deterioration just means diminished financial position. So a decrease in your financial position. There's been an increase in expenses, or you have lost your job. It's just, these are all examples of how your financial position will be diminished. So then you may apply for a variation order to have the amount decreased. However, a downward variation of a maintenance order will not be entertained if it is unreasonable in light of the child's needs. So the debtor must show that the deterioration, the diminished financial position, was not due to their own control. This is the slide I was talking about just now. So if you have deliberately made the decision to move somewhere where your expenses will be increased, this is unreasonable because it was within your control to know whether your financial position will warrant a variation or not. Whereas something as losing your job, or for example, you end up in hospital, and this now means that you are unemployed for the time that you are in hospital. That is not within your control. You did not control that circumstance, and this has now caused your financial position to be diminished. That will warrant an application for variation to decrease the maintenance amount, because this was not due to your own control. And also always remember that the child's needs, the child's reasonable needs becomes very important here. A silly example I can give you, for example, if you are applying for variation, your child is, for example, 6 years old. You are applying for variation because your child's needs have changed, because they now need a new cell phone. That is unreasonable because a 6-year-old child does not actually need a cell phone, because they can still use the cell phone of mom or dad. And so I would say that's not a good cause for applying for variation, because that child does not actually need a cell phone at 6 years old. But if the child is, for example, 16 years old, that might be a good reason why you're applying for variation, because that child might need a cell phone because they need to let mom and dad know that they are safe at school, or that they are walking home from school now and they're safe at home. Like, that might warrant a good cause for a variation, but not at 6 years old. That's just a silly example that I thought of just now of how you can, when you apply for a variation, what would be a good reason why you are applying, and also taking into account the reasonable needs of the child. Because a child of 16 years old or 17 years old, their reasonable needs look very different than the reasonable needs of a 5-year-old child or a 6-year-old child. So that should always be taken into account. Cost of living. So the maintenance amount payable will purport to cover the cost of living for the person entitled to maintenance, while still recognizing that the person liable to pay maintenance must also have enough funds for their own respective cost of living. So what does this mean? It just means that the person, the applicant that applied to court for the original maintenance order, that person, they applied for the amount of maintenance to allow their cost of living with the reasonable the reasonable needs of the child. So they need that amount to reasonably also live, if that makes sense. But then also we have to recognize that you cannot ask the respondent to pay a maintenance amount which is unreasonable, which will cause them not to have enough funds to reasonably live themselves. So there needs to be a compromise, because you want to take care of your child, but you also need to take care of yourself, because you still need to eat and you still need a roof over your head, for example. So that's why cost of living becomes important. An increase or decrease in cost of living may therefore justify a variation of a maintenance order. So in the case of Vidovatu versus Vidovatu, this is an example of a successfully proved increased cost of living, which justified the application for variation of a maintenance order. So always remember, this is not a decisive factor. None of them are decisive factors. They are just collectively considered to determine whether a variation is warranted in a particular case, because as we've said, each case is assessed on their own facts. So these factors just show that the applicant has good cause to ask for the variation. So the court in Levin versus Levin confirmed that a sudden unexpected increase in the cost of living will constitute sufficient reason for variation. These are just some examples, more examples of how cost of living will affect this. So, for example, now the cost of living, the rent has gone up due to inflation in the market. So you, instead of paying 5,000 Rand a month's rent, you now need to pay 6,000 Rand a month. And this has reasonably affected your cost of living. This may warrant application for variation, for an increase, because now you need to pay more rent and food has become more expensive. Your child is growing up, the child is eating more because they are now 16 and they're no longer 5 years old. So all of these factors play a role in why you are applying for a variation. So as I've said, inflation plays a role in the general cost of living. The court in Joffe versus Labner has taken judicial notice of the impact of inflation on spousal maintenance. And the court in Grosso versus Grosso held that inflation is not a decisive factor and other factors must be considered in conjunction with this factor. But inflation does play a role in your cost of living, because if your rent has gone up, that also means that food prices have gone up and your child might now, as I've said, be older, eating more food, they're packing lunch for school. All of these factors will play a role in why you are now applying for more maintenance. So cohabitation. Cohabitation and or remarriage of a divorced spouse may have an impact on their spousal maintenance order and the variation of such. So this is just an example of spousal maintenance. So when you get divorced and you've applied for spousal maintenance, the court may order that spousal maintenance to be paid, for example, a period of 6 months or until remarriage. So when you are remarried, that order will be discharged. But we are more focused on child maintenance and not spousal maintenance. So, which documents do you need when you apply for a variation? So, firstly, the J107 application form. That is the form that you will complete and you will give that to the court. You will need a complete statement of your income and expenditure and a statement explaining the reasons for the application. So remember, as I've said, it is a requirement that you need to show good cause and sufficient reason for applying. So you will have a statement setting out your reasons and then also a statement of income and expenditure. You will also need the documents that you required when you completed the J101. So your identity document, birth certificate of the child. You can also bring pay slips, stuff like that, indicating all the expenses of the child. It's a very similar process that is followed when you completed your J101 for the original maintenance order. So see it as the same type of process and bring all those documents that you brought initially together with your J107 and your reasons for applying. Okay, so completion of the J107 application form. So we know this is what the form looks like. So it's a substitution or discharge of existing maintenance order. So this is the J107. This will become your best friend when applying for the variation of a maintenance order. You will use this form. Okay, so it is completed. The form will ask you to deal with your current financial position, your income, your expenses. And as I've already stated throughout this webinar, it must be clear that the current financial position, that some change justifies application for a variation. Changing conditions. We've said this a million times today. You just need to prove that there has been a change in your circumstances, in your financial position, which now warrants your application for either an increase or a decrease. So when you apply for your J107, I would also advise going back to the Lunch and Learn webinar where Eugene Opperman discussed the J101 form and how to complete it. That is an in-depth webinar discussing what you should include in your form, how it should be completed. So if you're unsure, consult that webinar again, because the J107 looks substantially similar to the J101. So that would be my advice. If you are unsure how to complete this form, go back to that Lunch and Learn webinar, go through it, work through it. The J107 is substantially similar. The form will require you to detail the reasons for the variation. I've said this, you will also include a statement indicating the reasons why you are applying for this variation order. And as I've said, it's substantially similar to the J101 and will be completed in the same manner. So if you are unsure, please, Mr. Opperman has explained this form in such detail, so beautifully. You can understand it. Go look at that webinar again, and it will guide you through how to complete this form as well. That's why I'm not going over it in today's webinar. There's not enough time to go through the form again. So just go back, drink a tea, and watch through that webinar again, complete it on how to complete the form, because it is substantially similar. So detailing the process that needs to be followed for a variation. As I've said, the process as when you claimed maintenance initially, the same process is followed. You approach the magistrate's court nearest to where you live or work, or where the respondent lives or works. You can approach the magistrate's court where the original maintenance order was obtained. You can approach that court. They will have your case on file. You will ask for the J107 application form. You will fill in that form as you would the J101. You will have all your documents ready that you need to submit, and you will submit this to the maintenance court. The form is submitted to the maintenance officer. The maintenance officer will then conduct an informal Section 6 inquiry to determine the facts of the case in an attempt to settle the situation between the parties. If you are unsure what is meant by a Section 6 inquiry, again, go back. This has been discussed in a Lunch and Learn webinar in great depth, in great detail. Please go watch that webinar again. You can find it on the Lunch and Learn website or on the Facebook group. Go watch that video if you're unsure about the Section 6 inquiry. If you need a little bit of a recap, just go and consult that webinar. But then the maintenance officer conducts this inquiry to determine the facts, to see if he can settle the dispute. But if the variation is disputed, so for example, dad is applying for a decrease in the variation order, mom is not happy with this. She is disputing this. She is saying that there's not been a change in financial circumstances. Dad cannot apply for a decrease. No agreement is therefore reached. Then the maintenance officer will send the matter to court for formal Section 10 inquiry. So again, if you're unsure about the Section 10 inquiry, go consult the Lunch and Learn webinar dealing with this. There's not enough time today to go through all of that again, so therefore I'm just referring you back. If you don't remember, just go see again. But if no agreement is reached, it will amount to Section 10 inquiry. Okay, so what is the effect? So this order, the original maintenance order, is now substituted by a new order. So Section 22 of the Maintenance Act makes it clear that a variation deletes the initial order insofar as expressed by the court. So your initial order is now deleted. It does not exist anymore. Your substituted order becomes your new order that you will follow. So the original order is no longer in force, it has no effect, and it is actually replaced by the varied maintenance order. So what this means, the court has now granted this variation, for example, for an increase. This varied maintenance order becomes the one that you need to follow. So you disregard the original maintenance order. So the original maintenance order said that the respondent needs to pay 1,000 Rand a month, for example. Now the varied order says the respondent needs to pay 2,000 Rand. He now is obligated to pay the 2,000, not the 1,000. So you ignore that original maintenance order because the new varied order becomes the one that you follow. It is the one that will hold him or her, the respondent, accountable. So upon variation, the maintenance officer, will give notice of the decision to the registrar or the clerk in the jurisdiction where the maintenance order was initially issued. So the maintenance officer gives notice to the clerk or the registrar that that maintenance order has now been varied and that the new one is now the one that is in effect. Can a maintenance court override a high court order when it comes to maintenance? Very interesting. As we know, the high court is the upper guardian of all minor children, makes decision on behalf of children. So can the maintenance court override the high court order? Essentially, yes. Maintenance courts have the power to vary or discharge maintenance orders, including orders issued by the high court. So this is confirmed in legislation. This power is conferred upon the maintenance court by the Maintenance Act. So they have this power to vary or discharge a high court order. So they have this order. Any person aggrieved by the decision of a maintenance court, granting, refusing, varying, or discharging a maintenance order is also allowed to appeal to the High Court. So if you, as the respondent, you are unhappy with this new maintenance order which says you need to pay 2,000 Rand, you can appeal to the High Court to have that order discharged or varied again. Okay. So if an application for variation is brought in the High Court and it should have been brought in the Magistrates Court, an order for costs will be refused to a successful applicant unless they demonstrate to the High Court's satisfaction that there were circumstances and reasons justifying the failure to use the Magistrates Court. So just simplified, what this means is that if you brought the application in the High Court, but it actually should have been brought in the Magistrates Court, there will be no cost order granted to the successful applicant. So they will not be granted the cost order. Brief discussion about the increase or decrease of a spousal maintenance order made by a divorce court. So just briefly, because we are actually focused on child maintenance and not spousal maintenance, but Section 8 of the Divorce Act says that a high court or a regional court may vary a maintenance order if the court finds that there's sufficient reason to do so. The onus is on the party seeking the variation to show sufficient reason for it. So a court will consider factors in determining whether there's sufficient reason to vary a spousal maintenance order. So these factors are the income of the parties, the age of the parties, conduct leading up to the divorce, the health of the parties, and their ability to support themselves. All of these factors are considered whether there's sufficient reason to vary a spousal maintenance order. Thank you so much for bearing with me during today's Lunch and Learn webinar. We will now be having a discussion with Mr. Opperman, who is an expert in child maintenance. As you all know, you've been following the Lunch and Learn webinar series. We will now have a discussion with him regarding the variation of an original maintenance order.
Thank you, Erin, for that insightful presentation. If you have any questions, you're most welcome to email her as well. She will be able to assist you. I just want to discuss and come back and circle around a couple of issues that she has discussed. And one of the things that I think that is also vitally important is that one should distinguish that the variation of maintenance orders relating to children must be distinguished from variation orders for spousal maintenance for divorcing spouses. That is vitally important. Always remember that there's a common law duty of support on the respondent or the father to maintain his child up until a stage that that child is self-supporting, and then up until that stage that the child is self-supporting, that at any stage regarding the best interest of the child that you can apply for an increase for maintenance. There's a couple of cases that dealt with that. Erin referred to the Vedivatu case as well as the Green case. In the Green case, which is a 1976 case, the court actually acknowledged that as children grow older, the cost of maintaining them would increase. That is just a point that I would love to stress and bring forward. Another thing is the frequency of the variation. How often can you ask for a variation? Now, there's not a hard and fast rule. Some of the courts would tell you that you can come once a year. That is absolute rubbish. There's no such thing. In the Watson case, which is a 1979 case, the court clearly stated that and held that an application for a variation, for increase, upward variation, would not be refused if the true interests of the minor children necessitated such a change. With other words, if there is a change in any circumstances, that the variation order would definitely then be heard. We've discussed, and Erin discussed about the completion of the J107 form. Vitally important that I just would like to stress. If it is a variation order, it means that the one order would be substituted for another order. And please make sure that the maintenance officer substitutes the whole order. What is meant by that? If there is a stipulation in your maintenance order, for example, with regards to payment of medical fees, which is separate than the normal payment of the standard maintenance, or there is a stipulation regarding the payment of Christmas clothes or winter or summer clothes, then ask the maintenance officer to make sure that that portion is also included in the new order. Because what would happen now in terms of the legislation is that the old order would be replaced with a new order. And if the maintenance officer is not cognizant and they do not see that and they do not realize that it needs to be replaced, the whole order, especially the specifics regarding medical and or children's clothing and so forth, and payment of school fees and transport, if that was made a separate order as part of the initial order, and we see that, just be cognizant that that needs to be replaced and it needs to be included in the new order. We see that quite often with high cost divorce orders, where you have a divorce order, you go to the maintenance court for a variation, for upward variation, for increase, with other words, and then only a portion thereof gets substituted. The maintenance officer would just grant you an increase of the amount, but the High Court order actually stipulated that there are certain other provisions that the father also needs to pay. For example, transportation, tertiary education, school fees, and so forth. So vitally important is that you make sure that the whole order of the previous order gets replaced, and every stipulation of the previous order is also included in the new order. Just to come back to another question is about the cost of living. Yes, the court would definitely take into account that the escalating cost of living for households, and that was actually found in the Beekers case, where the court actually held that they would definitely take cognizance thereof. So in the situation where we live now in South Africa, where we have interest rates and so forth, yes, that would actually give you enough reason to ask for an increase for child maintenance. Joffrey versus Lubner, the case that also mentions and refers to that, where the court held that the children's legitimate maintenance demands needs to be met, but in realistic terms. We all know that there is no hard and fast rule of the amounts of the increase, and it all pertains to the best interest of the child. So what is in the interest of the child? If there's a need for the child, if there's a need for increase, then surely the court would definitely entertain that. We've also mentioned, and Erin mentioned, that there's always a good idea to file a founding affidavit, a supplementary affidavit, explaining why you consider it to be a good reason or good cause to ask for a maintenance increase. If you look at for those that have registered, if you look in the resource folder, you will find 2 applications or 2 affidavits, generously sponsored by advocate raters, dealing specifically with the stipulations, what needs to be included in the affidavits that you can file together with your J107 form at court. that is basically in a nutshell from my side. Our time is basically up. Thank you for joining us. My name is Eugene Opperman. I'm a family law practitioner. I've been practicing family law specifically for the past 23 years, specializing in maintenance law, domestic violence applications, as well as children's rights. Thank you so much for Erin O'Neill for the presentation and also for the handout. And we'll see you next week, same time, same place, for another Lunch and Learn session. You please reach out to us if you have any questions, any comments, any queries. And if you need some of the course material of previous webinars, you're also most welcome just to drop us a mail on info@lunchandlearn.org.za. Thank you, guys. Have a fantastic afternoon further, and we'll see you next week.